Good afternoon. How y'all doing? Hope y'all can hear me. I hope the rain is not too loud. Today we're going to discuss Siegel and Spaeth, the legal model, what their criticisms of the legal model are, and how they posit a counter model to that, which will be the attitudinal model. I decided I'm not going to cover the Angela Davis piece. She talks about criminalization in depth, but if you watch the 13th documentary on Netflix, you'll see that Angela Davis is actually interviewed in that piece. And they discuss criminalization a fair amount. All right. So I'm going to leave that to Angela Davis. She can explain her work better than I can. And I'm going to get into Siegel and Spaeth. All right. So the legal model really puts forth, it's a model of judicial decision making. So it's a way that we can understand Supreme Court decision making, federal judge decision making, state judge decision making, any of those. It's a model, right, for how they actually make their decisions. Now, this legal model puts forth 5 basic principles for how decisions or how cases should be decided. Right. The first of these basic principles is the plain meaning of the Constitution. Right, and that's obvious enough. You look at the Constitution, you see what it says. Right, Second Amendment says you have the right to bear arms. You have the right to carry a gun in this country. Right, plain meaning of the Constitution. All right. Secondly is this idea of precedent, right? So precedent is the ability of past cases or the ability of current cases to alter law or alter future law. So a good example of this would be that abortion was found illegal or made illegal in this country, not through any legislation, but through a Supreme Court case known as Roe versus Wade, right? So that's the ability of precedent to change law. So beyond the Constitution, you're going to look back at past Supreme Court cases. If you're going to make a ruling on the legality of abortion, per se, you look back on Roe v. Wade and you say, all right, in this case, the Supreme Court has ruled that it's illegal, abortion is legal, and we're going to keep with that rule. All right, so say look back on precedent. Thirdly, you could look back on the framers' intent, the framers being the framers of the Constitution, right? What did they really mean when they said they had a right to bear arms? What was their intent behind certain aspects of the Constitution, the Bill of Rights? Okay. So evaluate the framers' intent, right? Ted Cruz is somebody who advocates this. They're called a strict constructionist, right? Or a strict constructionist would be the way it's called. Beyond that, you have legislation. So what's the past legislation that's been passed in this country, right? Lastly, you would have legislators' intent. So you would look back on that past legislation and say, okay, what was the intent? What was the reasoning behind the legislations, right? And this is to be found not just in the models theorizing Supreme Court decision making, but it's also going to be found in the Supreme Court decisions themselves, right? So in every Supreme Court decision, there's an opinion of the majority. And then there's a dissenting opinion, which is going to be of the minority. There's 9 judges on a full court, 9 judges at the moment, right, with the confirmation of Neil Gorsuch. And so when they vote on a case, let's say it comes down 5-4, somebody on those 5 will write what's called the majority opinion, okay? And in this opinion, they'll give their legal reasoning for the case, and they'll cite these things, such as the plain meaning of the Constitution, right? They'll cite precedent, past case history, right? On the other side, there'll be a dissenting opinion, okay? So these things can be found in every Supreme Court ruling. It's not such a thing that we just theorize about as political scientists, right? This is actually expressed in the opinions. And again, Siegel and Spaeth are going to call this the legal model. Now, Siegel and Spaeth aren't going to say the legal model has no relevance, right? And Siegel and Spaeth believe that the legal model is going to be used to justify ideological decisions made by the Supreme Court justices. And when I say ideological, I mean their underlying political beliefs, those things that make up whether or not they will become Republican or Democrat, right? Their underlying beliefs in the size of government, for example, right? This is their ideology. So Siegel and Spaeth put forth what's called an attitudinal model. And this posits that it's really the attitude of the judges, more than anything else, the ideology of the judges. It's going to influence their decisions and not necessarily any of these legal factors, right? So Siegel and Spaeth are going to go through one by one and dissect each of these 5 pieces of the legal model, right, and criticize and talk about what's wrong with it. First of all, the plain meaning of the Constitution. There isn't necessarily a plain meaning in the Constitution. It's a very vague and ambiguous document, right? For example, it says to be president of the United States, you need to be a natural-born citizen. It doesn't state if Ted Cruz, being born in Canada to a woman who is a United States citizen, will qualify for the presidency. That's going to be left up to the interpretation, right? It's going to be the job of the Supreme Court to decide. Similarly, what type of weapons would be legal? What is cruel and unusual punishment? There's lots of ambiguities in the Constitution and the Bill of Rights, okay? So it's not easy to just say, okay, we'll look back on the plain meaning of the Constitution. That's part of why the Supreme Court exists, is to understand that complicated meaning. All right, secondly, when you look back on the framers' intent, or excuse me, precedent, to stay in order. When you look back on precedent, as I mentioned, right, you're going to have precedent on both sides of the case. Okay, so you're going to see, as I mentioned, a majority opinion and then a dissenting opinion for every case. The dissenting opinion is going to cite a host of other legal factors. So in any case that you're going to find confirmation for your ruling, you can also find refutation within that same case in the dissenting opinion. Beyond that, we see the Supreme Court make opposite rulings in the case of segregation, for example, with Plessy v. Ferguson and then Brown versus Board of Education. Within, in that case, 60 years of one another, right? So precedent isn't always cast in stone. It's not always a clear guidepost, right? When we talk about the intent of the founders, last week y'all just did a midterm that asked about the differences between the Virginia plan and the New Jersey plan. And it's clear that the Constitution between 2 different groups of parties, 2 different groups of individuals who wanted different things. There was no clear assertion of will, no consensus on what they wanted. It was a compromise. So there was no framers' intent. Right? Beyond that, when we talk about past legislation, the Constitution supersedes any past legislation. That's more important. So again, you're asking the Supreme Court usually to rule on the legality of this legislation in the first place. And lastly, to look back on those legislators' intents is even maybe more difficult than the framers' intent. How would you look back, let's say, 100 years into the state of Alabama and assume one common intent for all the legislators there, right? That would be just about impossible. So I hope y'all enjoyed this video. If you have any questions about it, please email me. Thank y'all for watching.